Is it correct to say you were an attorney for about 3 years?
I was an attorney for 6 years, 2 years as an article clerk and 4
Yeah.
years as a professional assistant.
Yeah, I excluded articles of the period for articles.
Then it
of
would be
clerkship.
4 years.
4 years.
Yes.
Yes. I couldn't resist, admiring your qualifications: BA Law, LLB, LLM, and MBA.
No.
Is it not you?
No, that's definitely not me, no. I've got a BA and LLB.
What is this about LLM? Yes.
No.
You don't have an LLM?
No, possibly you might, at the level of my attorney's experience, I did mainly maritime law.
Yes.
And then after that, I then went prosecuting before I came to the bar.
Okay.
But as far as
You
formal
prosecuted for 3
qualifications,
years?
I beg your pardon.
Did you prosecute for 3 years?
I prosecuted, yes. Between the time of I made up my mind that I wanted to go to the bar, and I didn't have any criminal experience.
Yes.
So I then prosecuted for 3 years. During that time, I worked a short period in the district courts, then up into the regional courts, and then I was what they styled as a specialist prosecutor. Well, I wasn't assigned to a court itself, but did various cases that were assigned to various courts that were of a commercial nature, or what they styled as high profile. There was a lot of gang-related type crimes of rapes and robberies, and that's the type of things that I prosecuted during that time.
Yes. And you've been an advocate for about 24 years?
Since 1992. I did my pupillage at the beginning of 1992, and I passed the bar exam, and I think it was June of that year.
Yes. Has it been about 24 years?
Yes. Well, from 92 to today, yes.
For how many years were you a junior?
I applied for Silk in 2012, but the applications were held up for 2 years as such because of the challenge to the president being able to sign honours.
Is that the Masin case?
Yes, it is. I think myself and one of my colleagues were one of the first that applied just before that challenge was made.
Yes.
I obtained, or I gave him my letters patent in 2014.
Yes.
But to an extent, those 2 years, there was a lot of stuff that I was doing possibly as a junior silk as such.
Yes. And you've had several acting stints at the High Court.
Well, I wouldn't say several. I've had one permanent stint, and then there were follow-ons from parterres from that and various appeal applications and so forth.
Is that permanent one for 1 month?
Yes. I think it was six weeks, I think it was.
It seems to be for 1 month.
It was during May last year.
Is it? Yes.
I think it was
May, June.
May, June, yes.
And then some 3 days in July, 3 days in August,
Yes.
3 days in September of the same year.
Yes.
Yes.
I was finishing off a parterre that perpetuated for quite some time, unfortunately.
Yes. And in your own words, would you just want to share with us some of the, additional qualities and experience you have as SC and as a practitioner for these number of years that have prepared you for the position you are applying for?
Possibly, well, I wouldn't be here if I didn't think that I could make a positive contribution to the KZN bench. And I think there I've had a varied experience as far as my practice is concerned. Both in trial type matters and also in motion court. I've done commercial matters and also personal injury type matters. Also, as far as my personality is concerned, I'm not a confrontational type person. I'm always prepared to let someone listen. I will listen to someone. Even if I don't agree with what you say, I'll defend your right to say it as such. And I think those are attributes that I can bring to the bench. As far as I'm concerned, a court hearing shouldn't be an argument, it should be a debate. There shouldn't be any fear, or the litigant should feel that the court hearing is fair, and it shouldn't be a fearful place, although obviously there must always be some form of decorum and control in the court, but that's my nature. And during the acting stint, I did get comments from my colleagues as that came across very clearly. In other words, although I dealt with things firmly, it was always done in a pleasant manner, and that's the way I feel a court case should go through. I also I think one brings one's life experiences to the bench, no matter what your background is concerned. And I haven't certainly, I don't want to take it too far back, but I was born on a farm. My initial friends as such were isiZulu children on the farm. I can speak isiZulu. I then went to an Afrikaans medium school where I then spoke Afrikaans or had to learn Afrikaans up until Standard 4. I then moved down to Durban when my parents moved down to Durban. I left school when I was 16 because I had to go into my father's business because he had an operation, and you'll see there I'm a baker at some stage. I completed my matric at night school. Unfortunately, you'll also see that my parents' business failed around about that time, so I had to put myself through university. So I'm not a person that's possibly been born with a silver spoon in my mouth, and I've made my way all the way through. And you'll also note I've always made sure or be confident in myself that I can do something before I do it. And hopefully I'm confident in myself that I wouldn't be here if I didn't feel I could actually make a proper and positive contribution and also be able to do the functions that will be assigned to me.
JP?
Thank you, Chief Justice. As I recall, you had an acting stint for one session.
Yes.
And that was largely civil, in civil courts in Durban, was it?
Yes, save for one bail appeal, yes, I'd say it's largely civil.
Well, what is your experience as far as the criminal courts are concerned?
Not appearing in criminal courts, but prosecuting in criminal courts at various stages. Also doing my initial time at the bar during preadeos and that type of criminal experience. But one follows one's practice, and my practice has drifted towards a largely civil practice. But I can't say I don't know my way around a criminal court, as it were.
What do you think that you uniquely could bring to the KwaZulu-Natal bench?
At the level of the life experience that I've just emanated now in my background, I think I've got the confidence of a lot of my colleagues at the level, and I say this, I get on with all my colleagues. I've got no bad blood between any of my colleagues. And also a lot of the attorneys that are briefed or brief me also have got confidence in bringing their clients to me. And those are clients of all, shall I say, races and so forth. So that type of confidence, I think, I can bring to the bench that people will see me as someone that they will try their case fairly and give them a fair hearing. I think that's what I can bring to the bench.
Now, how would your appointment further the cause of transformation as far as the KwaZulu-Natal bench is concerned?
I don't know what to say. One can see I'm white. But I think, I can't take it any further than that, but my background and ability to communicate in isiZulu and also to an extent in Afrikaans, and also I'm able to let people be relaxed, if anything. I can communicate at their own level and tell the odd joke if needs be and relax people in both languages.
Well, do you think transformation is important?
Very much so, very, very much so. It's an aim that we should all aim towards. And curing the ills of the past, yes, very much so.
Now, you practice in KwaZulu-Natal. You have sat on the bench during an acting stint. In your view, what do you think is the main challenge or are the main challenges of a judge in KwaZulu, and what do you think you can do about it?
Sorry, I'm not too sure following what you're saying,
Well,
Judge.
There's a lot of work.
Yes.
Yes. Let's just start there.
Well, at that level, as far as personally, I'm saying I have a very good work ethic. I don't leave things lying around. Just to an extent of, if anything, I'm light on resources because I don't need a typist. I produce all my own documents. I work on a word recognition type program that is very efficient. So if stuff does need to be taken home at night or done over the weekend, I can produce and do now in my practice a completed document by the next morning. So to that level, workload doesn't fear me at all. And like I've said, I've got a very strong work ethic. I've been working since 16 years old, and I don't intend to stop now.
Yes, thank you, Chief Justice.
Thank you, JP. Premier?
Thank you, Chief Justice. Just 3 questions. The first question is about transformation.
Yes.
I wasn't expecting myself to ask this question, but I'm attracted to it, or I'm pushed to it by your reaction. You declare yourself white immediately when somebody touches on transformation.
Yes.
And I'm wondering why you have to declare yourself white when transformation is being talked about, because it's not just about being white or black. It's such that it must be the first thing that must come up when we talk about transformation.
So,
but you will make your own comment there about why you react that way. The first thing, though, that I want to is when you look at transformation and assessing it in terms of speed and quality.
yes.
What's your assessment, just on speed and quality? You can make a comment on the first one if you want to.
Again, if I can also, there was also a comment made on one of the advocates for our transformation that there was nothing in my CV dealing with transformation. If I could deal with that as well. But my views is yes, transformation is important. But at the end of the day, the litigant and people coming to court are paramount as far as all of us are concerned. And one needs to have a perception that when one leaves court, one's had a fair hearing, no matter who it is. And that's why I think judges bring life experiences of anything to the bench. And those life experiences have to be wide and varied. And one also has to be, it's a delicate balance. One must not draw competent persons away from the bar and the sidebar and leave a dearth of persons that want someone of experience to represent them, to take those persons away and put them on the bench. It's a very delicate balance. But over time, and unfortunately, we live with our past, and it has to slowly change, but it has to be done at the level of the litigant, and the persons coming to court should always be confident that they're getting a fair hearing from both sides. In other words, the person representing them and the person hearing it. I can't take it any further than that. Just at the level of, on my CV, if one, as I understand the question or the comment as well, there's nothing on my CV about transformation. I don't view it as something that to make points on your CV or to gain points on your CV, but I cannot say that I've never been in a position where I can actually dictate large policy about transformation or change. But where I have been involved and been in a position to actually advance people, I've always done so. You'll note from my CV, I was the chairman or chairperson of one of the larger football and running and sports clubs in Durban. Now, that was at the end of the 80s, early 90s. When I became chairman, and I used the term, it was run by some very narrow-minded people at that stage. And I worked hard and helped transformation of bringing all races and all genders into the club. The criteria being if you're a good runner or a good sportsman, this is where we are. I also developed teams. I managed teams, and I did a lot there. You'll also note, and hopefully I improved those lives. I don't know. When I was you'll see I was on the governing body of one of the larger boys' schools in Durban. At that stage, I was the chairman or dealt with disciplinary issues, so code of conduct fell under my portfolio. There was a challenge to one of the other schools in Durban dealing with a nose ring, and there was litigation over it. That issue arose at the school I was on, dealing with young learners of the Muslim faith. If they wanted to lead prayers, needed what was styled then as a virgin beard. And there was the first reaction from everybody there, we have a code, this is our uniform, this is what it is. I brought in a policy there that all that the persons had to do was ask for an exemption to that code, and on proper and objective grounds, and after the application was made, many of the young learners who were then going to lead the pairs were allowed to grow beards, and it was accepted and went all the way through. At the bar itself, I don't think there's 4 years or 5 years have gone by that I haven't had a pupil. I even had a pupil when I was a silk. So I've helped in training. I've been actively involved in training. I've also formed associations, as one can call it, with juniors, either them calling for me as juniors and so forth. And always where I can, have introduced persons that would not otherwise have been known to the larger firms or the firms that I was associated, recommended them. And a couple of them, or 2 of them that I can mention now, have got decent commercial practices from there. So although I can never say, yes, I have done, or that there's no written document, I would hope that I have helped transform those persons' lives. But I view it as something that should be done, not to score points on a CV, if you don't mind me saying so.
Thank you very much. What are the 2 most critical challenges of the bench in KZN currently?
So, I don't know. I have a very, very positive view of the bench in KZN. The judges there are very competent. They're very approachable. It's a hard question for me to answer. I don't know. I don't have the answer. But I have no complaints about the KZN bench from a practitioner's side of things, and that's the only area that I've actually viewed at the moment.
Well, I'm aware that we have a shortage of judges. If you look at other provinces.
Yes.
Now, there's the first challenge that
Yes.
you are saying you're not aware of.
Well,
But I was going to ask you a question anyway.
Okay.
What do you think is the historical cause of this shortage? Is it because that province has a dominance of Zulus who may be assumed to be wanting to sort out their differences through stick fighting or something, and therefore not requiring courts and judges?
I don't think so. I've never seen that, as again, from a practitioner. At the level of, yes, there's a shortage of judges. Just, again, from a practitioner, when the trial rolls, although the allocation system is a new one and it seems to be falling in place. But just as a practical level, when one goes up to Maritzburg, although there's lesser trials on the roll, the workload of the appeal court there seems to drain away from the trials. So yes, I think there's very much so. Yes, a shortage.
That's a challenge.
And I understand what you're saying. So possibly I misunderstood your thing. Yes, I think as a practitioner, there ought to be more judges allocated to that division because of the workload. I think there's a massive workload in that, both in Durban and in Pietermaritzburg. As far as fear of coming to court is concerned, no, I don't. I think the litigants are quite happy in that court, the ones that I've come across. I deal a lot, or have done a lot, with personal accident type cases, personal injury type cases, actually mainly for plaintiffs. And the feedback, and then my clients and colleagues' clients, I've heard no adverse comment from anybody.
This much spoken about reluctance on the part of women generally, and black women in particular, to join the bench. Have you observed anything? Are you, if pointed, what role, if you find that there is indeed shortage, what role do you think you will play as a person, as a DJP, if you
That's a long way.
No, sorry, as a judge.
As a judge.
I
thought I'd come in at the wrong time. I do apologize.
I have a hang up. Yeah. What nevertheless.
It needs to be encouraged, but just go back to my previous comment. There are some very exceptionally competent senior female advocates at the bar. And they are needed there for a time possibly, until further people come through because of our past, then yes, a transformation through. But I have that fear that if all the very competent advocates go to the bench, it leaves a dearth of competence at the bar or not on the bench. Well, it's a balance. It's a balance. But very much so, yes, in time, there should be more females, should be on the bench. I think we've lost one judge recently that's moved off to another division. But yes, very much I support that.
You said you speak isiZulu as well.
Ngona ngiyakhuluma ngiyazama angikhulumi kakhulu ngakho into ungcwaba ngazi ngigcwalisa ngesingisi njalo nento futhi ngiyafunda isiZulu isikhathi ngengane yabona ngihluleka ukufunda ngiyahluleka ukubhala futhi ngiyakhuluma kuphela
Ngiyabona icala ungalithetha ngesiZulu
isikhathi sikancacelela
icala ungalithetha ngesiZulu
into ngakusaba futhi ngikhona phakathi inkantolo ngiyacabanga ngesingisi manje ngiyakutoleke njalo yabona manje futhi siyacoca kahle ngakusabisa futhi ngiyakhuluma Afrikaans futhi njalo ngiyakuthokeleka ngeEnglish na ngiyakutranslate njalo ngiyathi ngiyakusaba mafuthi siyacoca
cha uyazama thank you very much Chief Justice.
Thank you, Premier. Uyashaya impela ba.
Njalo ngiyakusaba ukukhuluma phela into ukuthi ungcwaba ngazi.
You know, there's a mistake here. The reason why I thought you had LLM and MBA is that there is a nomination of an advocate Gordon attached to the reverse side of your own nomination.
Well,
and this person is being nominated for the Western Cape. I don't know how this happened, but mistakes do happen.
Well, if I could accept those credentials graciously, I would do so.
Commissioner Mutimele.
Thank you, CJ. Can we continue in Zulu, this part of? I didn't hear you. No, thank you, Counsel. There is a judgment of yours.
Yes.
The Singh judgment against the Minister of Transport and the MEC in KZN.
That's
the one that relates to the rules of the residents.
Yes.
Remember that judgment?
Yes, I do. Very much so.
Beautiful judgment. I enjoyed reading it.
Thank you.
But the issue, there were 3 applications in one, as you style them, the rules application, the spoliation, and the trespass.
Yes, and then the rules application encompassed a counter application as well.
Yeah, but the facts were the same. I mean,
yes, they
it
were.
was the interpretation of those rules and the interplay of the freedom to contract and the public interest. Very narrow issues. I see you delivered the judgment on the judgment was heard. The hearing was on the 12th of June 2015.
Yes, it was.
And the judgment was handed down on the 4th of February 2016.
Yes.
Approximately 8 months.
Yes.
Any explanation why?
Yes, I can. If you'll note the judgment, it's quite a lengthy judgment. I was hoping, I finished my stint at the end of June, and I was hoping to use the July recess to work on that judgment. Unfortunately, I walked into practice just with urgent applications and matters that I had to deal with. I spoke to both counsel concerned and said, I need time. It wasn't the type of judgment, and I hope it comes through from the judgment itself, that one can write piecemeal. One just needs to sit down and concentrate on it. And I said to them, I can only really do that during the December recess. And both the counsel were quite happy. They'd spoken to clients and said, rather deal with it properly and produce the judgment. And you can see it's over 100 pages. That's the reason why I took time, because I didn't want to rush it, and I wasn't able to get to it with sufficient chronological period of time because of the pressures of my practice. And if I can just add on from there, what has happened, which is not evident from what's placed before the Commission, is that there's been an application for leave to appeal sought on the application and convention in the rules application. Otherwise, the rest of the judgment, there's been no challenge to at all.
The bulkiness of the application is in part duly because of the quotation, the verbatim of the rules of the
Yes,
association.
yes.
That's what makes the bulking.
Yes, and I had to put that in to make it read sense with respect, yes.
Thank you, CJ.
Thanks.
Thank you, Advocate Mutimela. Commissioner Helens?
Mr. Topping, you make reference to a reserve judgment that you have
Yes,
in the matter of Absa Bank and Garrison Hardware.
yes,
And it's now February. You say it's reserved because you only received written argument from counsel during January 2016.
yes.
Does this emanate from your acting appointment in June, July last year?
Yes, that judgment has been handed down. I've completed it and it has been handed down. And again, what happened there is that it became a bit of a perpetual trial. It went on and on and on. And what happened is that the council agreed to give me written heads and not give me oral argument. I received one during December, one during January. And I had to go back or try and ascertain from the plaintiff's counsel whether they wanted to reply to the other heads, which I only ascertained towards the end of January. And then I sat down and wrote the judgment, and I finished it during February, and it's been handed down now.
So the hearing, was this a trial or a motion?
No, it was trial. It was a part heard, and it went on for a number of occasions. I think it went on during September,
Okay.
and then it went on and on. And again, although the claim was only for 180-something rand over a telephone system, there were 5 special pleas raised on the National Credit Act, and it just turned into a perpetual trial because the defendants challenged every single document, so I had to deal with all that. So it turned out a bit of a lengthy judgment.
You've answered my question. I
Thank you
thought
so much.
it was a situation where you heard it in June or July and then only got heads.
No, it wasn't. No.
Professor Ntlama?
Thank you, CJ.
Thank you.
Good afternoon, Advocate.
Good afternoon.
Yes. There is a complaint from a certain Mr. McHenry,
Yes.
which you signed off on the 10th of June last
Yes.
year. Has it been sorted out by now?
I've heard nothing further since the memorandum, and I've heard no further, but I thought it pertinent to put it up because it was a complaint raised. And I assume it's been sorted out. There's been no comeback to me, and I don't know if the Judge President might assist. I really don't know.
So let's assume it comes back and we give you this opportunity.
Yes.
What impact would it have on us as the judiciary?
If one looks at what actually happened, and I'm working from memory now, please bear with me. It was a situation where it was a gentleman that was acting for himself in motion court. There were 2 files placed before me on the unopposed roll. It appeared from the documents, and I think I made the comment in the memorandum that I wrote, that the papers were not in order. There was just papers stuck in both files. I had to go through them to try and work out what was going on. But it appeared that the 2 had been consolidated at some stage. One was relating to a judgment that had been obtained by default for the sale of a movable property, which there was a rescission application pending, and the 2 were consolidated, and there was a note on the file that it appeared that both applications had been withdrawn. So when it appeared before me, I tried to get clarity on that point and tried to ask the counsel. There was the defendant, I think it was at the time, or respondent, was represented by counsel, although the applicant was in person. I tried to get clarity to get them to go and listen to the tape to tell me what actually happened because it was disputed. The applicant actually said, no, it hadn't been withdrawn. So I was sitting with that situation, and I explained to the gentleman in person it wasn't on the opposed roll. It couldn't be heard until such time as the record had been listened to and a transcript obtained, which the respondent's counsel offered to make sure that happened in time. And it was for that reason that I then adjourned it to a period for that to transpire. And again, I don't know what's transpired with the actual application itself. So with respect, I think I dealt with the matter properly. I do recollect that the applicant himself endeavoured to come and see me in chambers afterwards, and I said it wasn't appropriate. Well, I let my registrar advise him that it wasn't appropriate to do so without the respondent's counsel there. And I think he approached the then civil judge on duty with the same request and was told the same thing, and then I heard nothing further. And then I received a note saying there had been a complaint, and I drafted that memorandum. So with respect, I think it was dealt with appropriately, and I cannot see any comeback if the matter is taken any further.
Thank you. President Bati.
Good afternoon,
Good afternoon.
Mr. Advocate Topping. I'm just worried about age. I mean, some people can retire at 65 after 20 years service.
Yes.
Your age is now 61 and a half years.
61 years.
Why do you have to wait so long before you made yourself available for the bench?
I think it goes back to that notion that I have that I want to be sure I can do something before I do it. I always said that I would take Silk 20 years into my career. I applied for it in 2012, which was 20 years, was held up for 2 years, and I ought to be a Silk for 4 years now. But just at a level, I think age is a concern for everybody, but I've been someone that's always been younger than my age. I played over 35 league soccer until I was 50. I'm one of those type of people. I just couldn't chase the younger people anymore to get the ball back. But no, I don't see it as a problem. And I think the moment I stop working is the day I'm going to keel over, because I've done it my whole life. I'm an active person. My children are in the 20s. My wife is younger than me. No, I don't see it as a problem at all. I'm a young person, and I intend to 15 years of service if I can, yes.
Regrettably, at 75, you'll have to leave anyway, even if you want to stay
14
on.
years of service, yes.
Thank you.
Okay. But I really don't see it as a problem. I'm an active person, yes.
You are excused, sir.
Thank you very much. Thank you very much for your time.
It's going to be time for deliberations if the room could be cleared.